Thank you, everybody. I am here to introduce our next speaker. It's Paul Gehringer. He is a principal faculty specialist and extension specialist with the University of Maryland. His topic is the ag law shift in 2025 and beyond, covering recent state right to farm ruling, evolving PFAS litigation and regulations, and key legislative change impacting agriculture today. So, Paul Gehringer.
Good morning, everybody. So yes, and I realized as Kristen read that off, I forgot to put PFAS litigation in here, so we're probably not going to talk about that today. So we will go ahead and get started. And I want to remind you that university programs are open to all.
This institution is an equal opportunity provider.
Okay, so now we'll go ahead and get started. So as I often start these off with, today's going to, I don't even change this slide every year. It just changes from template to template depending on what the university tells me to use. But today's going to be my therapy session with you guys. We're all looking forward to that, aren't we? We've had a few weird decisions over the past year or so. One of which happened a year ago while we were meeting, and I couldn't put in my update, but we're going to talk about it today in a few minutes. We're going to look at the state's right to farm decision. Some of the slides you've probably seen before, so I need to run you through the timeline to talk about how everything has happened. NEPA, IPCRA. Tyler's already talked about MPRP, but we're going to talk about some of the litigation that's ongoing in that. And then we got a few other issues in mind. See how good I am at this? Yeah. Keep in mind, I have no idea how any of this will play out. Because if I knew that, I would not be here and I'd be living on a beach somewhere because I could do a lot better playing the lottery or sports gambling. So let's get started with the state's right to farm decision. You've probably seen this slide before. I've used it a lot. It rarely changes because we need the timeline to talk about this. This was a case out of Talbot County. Looking at it, farmer buys farmland in 2020. Sometime in 2021, still not clear, the operator begins to switch their nutrient management program and store basically a combination of DAF and seafood waste on the property to be used on other farms over time as a part of this nutrient management plan switch. They'd switch from chemical fertilizers to much more organic type fertilizers. In 2021, the neighbors began to complain about the smells associated with this on the property. When it goes through the process, it goes before the Talbot County Ag Reconciliation Board. That Ag Reconciliation Board found, as Maryland law allows after some hearings and some reviews by experts, that the right to farm law applied. It goes to the Talbot County Circuit Court. Talbot County Circuit Court says, nope, does not apply. Farm did not meet the one-year provision. Now, I should say, under the Talbot County ordinance, they found it met generally accepted ag practices and was compliant with the Talbot County law. And Circuit Court comes in and says, nope, doesn't apply because the farmer had just bought the farmland. Maryland's right to farm law requires the farm to have been in operation for 1 year, and the suit was brought 1 year before that, or before that 1 year period had expired. Now, it didn't matter to the Circuit Court that the farm had been used for farm ag throughout its history. It just mattered when the farmer bought it. What problems does that create? Y'all didn't know I was going to ask questions while I stood up here, did you? It means every time we potentially had a new farm being bought or leased by a new farmer, that 1 year provision would reset. That's appealed to the appellate court. The appellate court goes through the legislative history, looks at it. The law was revised in 1998. What happened in 1998? None of you will be brave enough to tell me. The Water Quality Act went into place, right? Mandatory nutrient management went into effect in the state. I really hope I'm right on all that because I was a junior in high school in Oklahoma at that point, so I wasn't living here, so this is what I understand happened. That law was amended in 98 to basically take out the reset provision that existed in state law at that point, because the Maryland right to farm law had this reset provision that if you change the operation in any way, that 1 year provision reset and you started over to get that 1 year. They did that because everybody was going to have mandatory nutrient management at that point. So farms were going to be technically changing operations at that point. So change from commercial fertilizers to biosolids, didn't reset the clock. And the court highlights the debate that went on in the General Assembly during this. And the General Assembly knew when this happened, you could have a dairy switch to a poultry operation. They highlight a whole bunch of other things that they knew, but that's one I put in here and can remember. Then they go in and look and say, yes, the county did everything. It met generally accepted ag practices, and they had developed substantial evidence. I'm going to get to the Maryland Supreme Court decision on the next slide. Who thinks the Maryland Supreme Court agreed? Let's have some show of hands. And for those that already know the answer to the question, you're right. They did not agree. It gets to the Maryland Supreme Court, and it's, nope, you're all wrong. At no point was the circuit court supposed to start off with a review of that 1 year provision. No one had actually ever brought that before any of the boards. The circuit court started this, the appellate court followed it. No one had actually appealed on that. The decision before the Supreme Court, when it looked at it, was the county's record supported by substantial evidence? And I don't think Tony's in the room, because I think Tony and I would agree that there probably was substantial evidence to back this up, but the Maryland Supreme Court did not agree with that. The Maryland Supreme Court said there's not enough substantial evidence to back this up. They had not looked at the public health impacts on the neighbors of this, because a lot of the concerns had been public health related. Under the right to farm law, if it's a public health concern, the right to farm law does not protect you at that point. So there wasn't enough evidence developed on that. And the court didn't rule on the generally accepted ag practices. And then finally, they did not send it back to the county board to make another decision and develop the record. They just said these parties could go to court. So that's where we're at with that. We're working on we're actually working on 2 law review articles, one looking at the court's decision, and then one going through the legislative history to build that case as to what was happening in 1998. Okay. How many people know what NEPA is? The National Environmental Policy Act. Why are we talking about that? Well, as I pointed out last year when we had this conference, on the exact day we had the conference, the D.C. Circuit Court of Appeals invalidated all of CEQ's regulations related to NEPA. The Council on Environmental Quality is the group that is established, and I'm making sure I can remember this. I've been to a lot of cities over the past 3 weeks, and my memory's not as good. The Council on Environmental Quality was established under the office of the President and is technically not an agency. Congress established their executive order, if I remember correctly. Now, throughout the history of NEPA, since about the late 1970s, Congress and the executive have kind of put together this framework for how CEQ would operate. Under the D.C. Circuit, they said none of this is valid, and Congress never gave them the authority to do any of this. Now, this could have been appealed, but it wasn't appealed. The D.C. Circuit didn't agree to hear it en banc, which would mean all the judges on the D.C. Circuit would have heard it in review, not a 3-judge panel. And the current administration decided not to press it for a Supreme Court review. I'm not going to talk about the Supreme Court decision that happened last year because I find this one much more interesting in all of this. CEQ in April of this year rescinded all of the NEPA regulations, leaving it on individual agencies to sort of develop their own regulations as it goes forward. Now, the reason I highlight this is, one, it was a 2-1 decision. The judges were never asked this issue on appeal. Normally, they don't do that. They brought this up themselves in doing this. And it was led by one judge, Judge Randolph, who took the time to go through and actually show how these should be invalidated. This is actually something he's been on for years. How many people remember me up here years ago talking about a NEPA case involving a Maryland poultry farm? He was the lone judge that actually wrote a concurrence in that case that actually talked about this issue. And this has been an issue he's been on for years, that CEQ might not have the authority to actually do any of this stuff. So that's where we're at. Like I said, DOJ did not appeal the decision, and USDA has implemented interim regs through this process. I was reviewing them again this morning to make sure I could remember this. It does appear that loan guarantees are still in there for review, and this could create potential problems for farms, especially if we're seeing like poultry or dairy operations going out for that, still having to have USDA go through that process, creating some delays within that process. Oh, okay. Our next one, the Emergency Planning Community Right to Know Act, IPCRA. I'm going to use a lot of acronyms today because it's just easier for me to say acronyms. So, and Jenny's in the room, and Holly's in the room. They all remember in 2018 when we tried to go out under 2 laws, and don't ask me to say what CERCLA means because I can't remember. It's a comprehensive recovery something. It's Superfund. It's Superfund. It's the Superfund law. Under this, if certain chemicals are released in reportable quantities, you have to report that to basically the Coast Guard. And that is put into a registry, so basically federal agencies know where these are being released in case there's an environmental response that has to happen, and communities also have a response to this too, so they can have the emergency planning equipment they need. We all want firefighters, first responders to have the safety equipment. This is one of the laws that allows them to know what's going on in the equipment they need to have. As a part of this reporting requirement, where we went back and forth and kind of helped farms go through this with some of the releases that would happen from poultry and dairy operations within reportable quantities, we did that, I think, 2017 and early 2018. Congress exempted ag operations under CERCLA. They did not exempt them under IPCRA. After that came out, EPA worked on an interim rule and then a final rule that basically said IPCRA didn't apply to these operations either. Let me go to the next slide where I have all this. EPA was sued on this by a number of environmental groups, and the district court in DC agreed with them, or agreed with EPA on this. A lot of this is based on the fact that CERCLA was actually passed first, and when Congress passed IPCRA, it was designed in a way to where reporting requirements under CERCLA were similar reporting requirements under IPCRA. Is that all making sense? So if you had to report under CERCLA, you have to report under IPCRA. EPA's viewpoint was, because you don't have to report under CERCLA anymore, there is no reason for you to report under IPCRA anymore, and they developed this rule based on this long-standing history they had based on IPCRA for about 40 years. The other thing that was fascinating in this decision, and I'll show you where you can read something all about this that I helped co-author at the end. IPCRA, there was also a requirement that EPA never did a NEPA review under any of this. And the district court agreed that EPA was not required to do the type of environmental review that the groups were looking for in this. This decision is currently under appeal with the DC Circuit, so we don't know at this point what's going to happen with that. It may be an issue in the future. It may not be. Oh. Now we're going to talk about power lines some more. Although Tyler has already taken up a lot of the first couple of review slides, but that's mainly for the person that may look at this later to look at. Now you can all boo and hiss me for talking about eminent domain real quick. So Tyler already talked about this. The Maryland Piedmont Reliability Project, 65-mile proposed line. I'm not going to spend a lot of time on this slide. The one thing I want to talk about is some of the ongoing litigation with this. So first, we have a preliminary injunction that the project has sought against all the landowners who are involved in this litigation, who are in the proposed path. This would allow them to be able to go out, give notice, go out, do the survey work, and start the process to figure out where the power line would end up being at. They sought this basically based on the fact that a number of landowners out there had said, we're not going to give you access to our property. They have to have access to be able to begin the process, so this at least allowed them out on the property. So under the existing injunction, they have to provide 48 hours notice before they come out on any of the properties, and that decision is currently under appeal to the Fourth Circuit. So that may or may not change, it may or may not be upheld. But at the same time, here recently, they've sought to expand that injunction. The reason they're seeking to expand it is within a number probably of social media posts, direct contact they've had with landowners, they've said those are the days they'll go hunting on their property. So the Piedmont Reliability Project folks have requested an expansion of that to include hunting on properties. So once they know when they're going to be out on the property, there will be more notice requirements for those that want to hunt on their properties and be able to utilize their properties in that, and they will have to get permission before going out, especially if there are going to be surveyors out that day. I already kind of talked about part of this. They've also sought to expand the injunction against one individual, and I won't name the individual. That would be mean to do in public, even though it's in the public record. One individual in particular, if you read the motion to expand it against this individual, they have done a lot of stuff. They blocked the road. They've taken a baseball bat to surveyors and threatened them with it. So they are seeking to expand the injunction against this individual to prevent them from doing any interference with the individual. If you're going to fight a power line, you might want to be smarter about it than like threatening them. That's probably not going to be the best way. The only way I figured out this case was out there, and there are like 4 cases filed in this process that you have to look at, is there was a date for when the motion came out for the hunting. I looked through the things, I found the first one that had that date. I opened it and I went, nope, this isn't about hunting. This is about an individual creating havoc. And then went into the hunting one finally. And like Tyler pointed out earlier today, If you want to read about eminent domain and learn more about it, you can read what my legal researchers did and put together on this and talking about how that eminent domain process would work, what all you're allowed to do, how you can file to be an intervener or work with groups that are already filing to be an intervener, and kind of how that process would work on preserved farmland and just unpreserved farmland, all at the same time. That has been a fun process to work through because we have a lot of preservation programs in the state, and a lot of the rules are different depending on the preservation program. In fact, at one point, I originally thought you couldn't condemn preserved farmland because MET had it on their website, you couldn't. But MALF has different rules than MET. Okay. So what are some other issues we need to be thinking about? And I'm going to leave y'all time to ask me questions because I think many of you have questions you want to ask. And I'm not even going to try to say neonicotinoid today. I might get it out today correctly. California Federal District Court agreed with EPA in exempting seed-coated with neonicotine pesticides from going through a separate FIFRA process. FIFRA would be the process as to how pesticides come onto the market, create the label for those, and regulate how those come on. The district court agreed with EPA that because those had already gone through that process to be regulated as a pesticide, no further FIFRA process was required in that case. At this point, with dicamba, EPA has set out and already put out a proposed re-registration. I believe it's up on their website if you want to look at it. For the 3 over-the-top dicambas, they would have new restrictions with buffer zones and some spray restrictions associated with those. This is being done because last year the Ninth Circuit invalidated the registration process, and those 3 products have really not been on the market this year for growers to use. So we're looking at that potentially being back next year. One case out of Maryland, excuse me, we had a treated wastewater plant that was, water was being utilized from that plant on a farm in Maryland. This was a state court decision. I believe it was a state Supreme Court decision, but it could have been the appellate. I forgot to write it in my notes. With that, as a part of that process, they were sued with an expansion that they needed an NPDES permit to be able to do this. So they would need a point source permit to be able to apply this because we would have a point source with this spray irrigation and need to be able to do that. So with that, the Maryland Supreme Court agreed it was not required to have a separate NPDES permit for this, for the treated wastewater that would be applied on farmland. The other thing to talk about, and this is the last thing I'll talk about, and then I'll wrap up and you guys can ask me questions. This will be fun. So, H.R. 1, which I believe when it came through Congress was known as the One Big Beautiful Bill, but the bill title was cut out by the Senate parliamentarian during the birdbath, so it really has no name, and I forgot to put in the public law when I put this together on Friday. This has created a lot of stuff that we're going to have to pay attention to within the ag space. There have been changes to payment limitations rules. There's also mainly focused in on how we can use pass-through entities now. Previously, under the old payment limitations rules, if you had an LLC or a corporation, that counted as an individual and then counted towards sort of the payment limitations, and we would discount if you'd gotten it as an individual as to how that would go through if the owners of that had done that. Now they're going to be counted the same way as partnerships. We're just going to look at them and look at the number of members or shareholders, a part of that are actively engaged on the farm, and we're going to basically do it the same way we do payment limitations for a partnership, where the members of the entity can collect up to the full amount of whatever. I can't remember what the payment limitations are. Payment limitations will all now also be set to an inflation rate each year. There's some stuff with reference price to where if a new farm bill is not passed, it automatically goes up with inflation during that time. One of the bigger issues too within all this is just looking at this idea within the law of, for those that remember, there would be no tax on overtime, right? No tax on overtime. The question is going to be for farm workers, and no tax on overtime. The law appears to set it towards the Fair Labor Standards Act. Under the Fair Labor Standards Act, ag labor is exempt. If you're in Maryland, are you exempt in theory? Not really. If it's over 60 hours, you have to pay overtime. So are those workers going to have their overtime income exempt from income tax? We don't know the answer to that. Maybe the government will reopen soon and we can get some answers to that. Early on in all of this, and my dad's not here to defend himself on any of this, so I'll tell this story. My dad called me and goes, "Paul, how many hours a week do farmers work?" I go, "I don't know, Dad, a lot." He goes, "I'm not going to have to pay any taxes on my overtime." And I went, "Yeah, but you're not hourly paid, Dad. You're salaried. You're like me." And he goes, "Yeah, but I shouldn't have to pay taxes on that. It's my overtime." I go, "It's also probably exempt under the Fair Labor Standards Act, so you're still going to pay taxes. And you should go talk to your accountant about this crazy idea you have. They should deal with you, not me. They should tell you this is a bad idea." Okay. I'm doing good on time. So we've seen a number of developments over the past year, state, federal, local, that will impact farmers in the state. The NEPA thing, I think, will have some ramifications. The biggest one's going to be with the right to farm law and looking at how do we set up processes that potentially meet the qualifications that the Supreme Court has told us we need to meet. The power line issues will only grow in the state. As Tyler pointed out, we need 128% more transmission capacity in the state. This is not a one-time thing. We're going to deal a lot more with eminent domain. In fact, I'm working on a project right now to where hopefully if it's funded, we can do some standalone online education where farmers can just go in and look later when they need to learn how eminent domain will impact them, especially as we see more and more transmission lines come in. And we're always going to see litigation around herbicides in ag. My guess is once the new dicamba, over-the-top dicamba registrations are applied, there will be a lawsuit filed in Arizona. Does anybody remember why we filed litigation for pesticides in Arizona? It's the only state in the Ninth Circuit that currently has approval and uses those products. So it's the only way to get into the Ninth Circuit to eventually maybe get it invalidated. Again, it's been invalidated 3 times. Let's hope the 4th time is the charm for EPA. And we're going to have to pay attention to just what's going on with H.R. 1, the bill formerly known as OBBA, and just how it's going to be implemented and what are some of the implications to farms going to be. There's going to be a bigger use to where we know farms can be set up with LLCs and corporations much more easily now, especially those that are trying to, utilize farm payment limits much more efficiently. The other thing I didn't include in all this, and I forgot the PFAS stuff even as I put the wrap-up together, is we have to think about the Make America Healthy Again initiatives and how that's going to impact stuff as well. We're already seeing states move to sort of put new policies in place, some of which I never thought would be put in place in states like Texas where they said they would follow whatever EU guidance was. Whoever had that on their bingo board won money this year. There's a lot of people that help me put this together because I just follow a lot of blogs that help me keep up on stuff, National Ag Law Center and a couple others that help me do this every year. If you want to know all that, you can talk to me and I can tell you what I use. And then I'm a part of this. This is where if you want to learn about IPCRA, the IPCRA stuff, me and Tiffany Lashmet put together a post on this, on that case for Southern Ag Today. You can sign up there. We do ag policy, trade, ag law, community development, local food stuff. Comes out every weekday. Ag law is 3 Fridays, and then 3 Fridays we're off. And then I do a blog at agris.umd.edu. And I left you 10 minutes for questions exactly. So what questions do people have? Yes, sir.
On the right to farm law, is that going to cover more in storage too, as far as they can implement ponds, impoundment ponds, and that type of thing, or building tanks on the farm, and then the CERCLA and the IPCRA, is that the continuous ammonia emissions, and that could cross over and cover wastewater plants too, couldn't it? I mean,
Yeah, it would.
That decision.
Yeah, with IPCRA and CERCLA, that would include wastewater treatment plants. The problem we ran into when we were trying to do it on poultry and dairy, and Jenny will remember this vividly, it was at reportable requirements for ammonia and 2 other chemicals I cannot remember that come as manures being broken down. Yeah, and the problem is if we're dealing with a farm, what changes throughout the year? It went from being summer to like fall, didn't it? Temperature changes what the chemical breakdown's going to be. Dietary practices change what it's going to be. If we're in a dairy, if the cattle are pregnant, it changes the ammonia releases. If calves are out and we're milking, it changes the ammonia requirement. So it was never just, what we were coming up with was a continuous number when it's not continuous throughout the year. So it was always hard to kind of pinpoint down who should have to report and who shouldn't. And it was almost err on the side of reporting than not reporting in that. And I have other thoughts on how that was implemented, but we can talk later about that. With the right to farm law, I think a lot of it's going to depend on just getting, if it's going to go through a county board, getting the county board to develop the record that's going to work with storage or anything to show it's generally accepted. And some of this would have changed just based on how MDA has changed the regs related to DAF usage. And this probably would have been less of an issue today than it was 5 years ago. I think I hit everything. Oh, now I see the hand where she's walking to.
Here's a book for you to write. How would you compare Maryland's farming under right to farm to a state like Vermont, where that doesn't exist at all? And I have a theory it has something to do with topography, really. But for instance, I mean, our 210-acre corn, wheat, soybean farm in Kent County abuts a farm that grows feed for Horizon Dairy. Their farmer is on their field 3 weeks a year. They're doing it right now, spreading the manure. It takes 3 weeks. It's 10-hour days. It's 3 10,000-gallon trucks going up and down our road for 3 weeks so that people in New York can buy Horizon organic milk. Now, up in Vermont, they are a certified organic farm. Up in Vermont, they would not be a certified organic farm because our corn, wheat, soybeans, does use Roundup and all that. What's the question is, are we better off in Maryland with right to farm, or would we rather be like Vermont?
I don't know Vermont's off the top of my head, but as I've talked to other people in other states that deal a lot with right to farm, and there's like a group of us ag lawyers that love right to farm and deal with it every day. A lot of states like our law just for the fact of the local review. The one thing I didn't point out with the law that it does allow is you can either have this county board review it, or it can go to the Maryland Department of Ag and have mediation done on it. This case would have been 100% different if mediation had happened in it. Guess what you don't have in mediation? A record. You cannot review a mediation. You can review a county board decisions. We would have had a 100% different outcome with this. And I know a number of the counties that have the county boards have been using mediation. I know there's some ongoing cannabis complaints in southern Maryland and a few other counties where they have boards set up, but they're going through the ag mediation program to kind of prevent review. So I think in a lot of states, they like what we have that helps provide much more review and keeps costs low for farmers. I got 4 more minutes. I cannot because I didn't review it before I got up here. And it would be a lot of me speculating and trying to remember out of my head.
Thank you. Can you talk about what we might see in the Maryland legislature 2026 to react to deal with MPRP issues and all that going on?
I cannot, mainly because I'm not a member of the legislature and I haven't seen any of the proposed bills yet, so I don't know what's coming on some of that. So I'm not the best expert. Tyler may know more than I do on some of that. But I believe we're in the pre-filing starts soon, and then we'll have an idea. Any other questions? Well, if not, thank you guys. And I got asked to introduce our pre-lunch speaker. Our pre-lunch speaker is Dean Laurent, the Dean and Professor of Law at the University of Maryland Francis King Carey School of Law in Baltimore. And I will turn it over to you because I don't feel like you want me to read your entire bio.
So good afternoon, everybody, or good morning. I think it's still morning at this point. I am going to try to get through this without coughing. And pre-lunch speaker is probably a bit of a stretch. I'm just here to say welcome. I know that I am the only thing that stands between you and lunch and a bathroom break. So as Paul said, I am Renee Laurent. I am the Dean of Maryland Carey Law. And it is really a pleasure to be here with you this morning and to be at the conference. I come to these conferences every year, and it's wonderful to be here again. I wanted to take a moment to thank the ALEI team and the conference organizers. And I wanted to express my appreciation that the law school gets to be a partner with the ALEI. So I don't know about you guys, but for me, it feels a little bit like the world is spinning a little bit too fast all the time. And federal policies are being transformed very, very, very quickly. It's really, really hard for the lawyers to keep up. And the impacts this year, I am sure, have been particularly hard on farmers and those working in our food system. So it has got to be dizzying to imagine how hard it would be to keep up with changes in everything from global trade to SNAP benefits to grant funding opportunities for climate smart ag to local food pipelines to food labor protections, to name just a few of the changes that we have seen. But that highlights just how really critically important the work of ALEI is. It also amplifies the really critical idea that is, for me, especially relevant during challenging times. And that idea is the idea that the power of institutions and people joining together is always stronger than us working alone. In the case of this Empower relationship, that purpose and the purpose of us working together is to assist farmers with legal issues in a way that helps to sustain and strengthen Maryland's agricultural community. And by working together, our impact is so much larger than any of us would do on our own. And that is a primary reason why we at the law school deeply value the Empower relationship among the 3 campuses. It increases our chance of making a difference, which is what we really do want to do. To tell you a little bit about what we've accomplished, our partnership has enabled us to participate in some recent clinical and community outreach programs. So we did a Know Your Rights Center for farmers through our Chacon Center for Immigrant Justice. We offered logo and copyright guidance through our intellectual property clinic. We assisted MDA with local food procurement research through the Brinsfield internship program, and I learned as I was preparing for the remarks this morning that that program is now in its 7th year, so that is sustained success. It has also been an incredible privilege to host events and offer courses that give students specialized knowledge and instruction on ag law, like the panel discussion that we are about to host at the law school on regenerative agriculture and indigenous traditional ecological initiatives, or Megan Todd's seminar on food, farming, and sustainability. And as to these last items, I think that they really speak to our commitment not only to being a legal resource for farmers, but also at the law school, it is very important for us that we create that next generation of ag lawyers who will spend their careers helping farmers, like many of the folks here today, to navigate all of the complex array of laws that affect that work. This partnership helps us to do that. So in closing, I would just say thanks again to our collaborators at College Park and UMES and to Empower for fueling our endeavors. We really look forward to continuing our work together and to expanding our efforts to partner through our common purpose. So thank you all, and with that, I will release you to lunch. Thank you.